Hi, guys. Welcome to Parawomenradio. I'm Amy. Sarah Boone, also known as Blame Boone. We've come full circle back to you once again. Sarah Boone, also known as Suitcase Sarah, the Florida woman who thought it would be a great idea to zip her boyfriend up into a suitcase during a game of hide and seek. Clearly, no one bothered to explain the rules of the game to Miss Boone. But here we are, once again, talking about her, albeit a bit late to the party on her latest shenanigans. So let's catch up on the latest trashy juice. She recently had a motion hearing where she managed to score a major win, and now she's taken up the noble task of writing her own ads for lawyers. Oh, I said it, and you heard it right. So let's get into this and more on today's special edition of Parawomenradio. Tune in for all the juicy details about our favorite Florida woman, the self-anointed Blame Boone. I'm going to roll some credits while we wait for all the other Blame Boons to roll in. Special shout out to my Dragonflies and Power Replay crew. It's Monday, but just ignore it because I'm giving total Friday vibes. Welcome to Parawomenradio. I'm Amy.
Carefully strumming this old guitar, words rolling out into the fire. Never ask why my heart burned blue. Here in the haze where you inspire me. Here in the darkness I hear my cue. Time to find some solitude. Here where my soul bleeds openly, deep in the heart of sin and you. Here in the blue, I'm falling deep into you. Here in the blue, I'm dancing with you tonight, and it feels fine. Carefully strumming this old guitar again, words rolling out into our fire. If heaven had wings, I would steal them and fly away with you for a while. Here in the essence of gratitude, your dreamy little smile on my lips. I miss my cue, but baby, I had you. Miss my cue, but I had you for that day.
Here in the essence of gratitude, I'm feeling really good. So I'm doing an extra Parawomenradio. I usually go live on Sundays, Wednesdays, and Fridays at 8 p.m. But sometimes I like to throw in some daytime lives. I don't usually do them because of the little bird. He likes to join in. And that's just what the daytime lives will have to be like. It'll be Junie Vision. Judy will be taking over the airwaves. he is in the back room, but he started turning on the bathroom light. So it makes me scared to leave him back there. So I'm going to open the door and look in a minute and see what he's doing. Ugh. What was I thinking when I got a bird? They're wonderful creatures, but you have to really think about it, because it's like getting a 2 to 4 year old for, well, depending on the bird. You get, my bird's a green cheek and they lived about 30-35 years. So yeah, that's what I've got to look forward to. But I love him, so he keeps me going. So does the little dog. All right, so today we're going to talk about Sarah Boone, because I'm behind. She's had some things happen. She's had some motion hearings, and she has more letters she's written. And yeah, so Sarah Boone is the Florida woman that zipped her boyfriend up in a suitcase. I'm going to show you some footage that we've done before we go into it, so that you can kind of get an idea who we're talking about, in case you're not quite sure who Sarah Boone is. And like, not everybody knows who Sarah Boone is, despite the fact that Sarah Boone thinks that everybody knows who Sarah Boone is. And she's self anointed herself Blame Boone in one of her letters. So, you know, we gotta like call her Blame Boone here and there. Try to use it in a sentence for her. Sarah Boone is known for her shining letters, but tonight's masterpiece truly takes the cake. For those that may not remember Sarah Boone, Sarah Boone is known for her shining letters, but tonight's masterpiece truly takes the cake. For those that may not remember Sarah Boone, she is the infamous Florida woman who thought it would be a fun idea to zip her boyfriend up in a game of hide and seek. However, her idea of fun quickly turned into a nightmare.
For everything you've done to me.
Sarah.
You.
Sarah.
She refused to let him out. To top it off, she decided to film herself mocking him while he was trapped, slurring her words in a drunken stupor. Unsurprisingly, Sarah then proceeded to pass out, only to wake up the next morning and discover her boyfriend no longer among the living. 2024, Judge Michael S. Kranick, Orlando, Florida, regarding Sarah Boone. January 19th, 2024, Judge Michael S. Kranick, Orlando, Florida, regarding Sarah Boone. Honorable Judge Kranick. Finally, a new judge. It's strange how the Lord works. As I was in the process of trying to disqualify Wooden, I felt he was the ticket holder to my overly hyped, illicitly distributed, misconstrued criminal case. Do you think she just sits with a dictionary right next to her, and she just closes her eyes and goes, what word am I going to use this time? January 19th, 2024, Judge Michael S. Kranick, Orlando, Florida. Guys, welcome to Parawomenradio. I'm Amy. Suitcase Sarah goes to trial on May 13th, 2024. She's the one that zipped her boyfriend up in a suitcase and allowed him to suffocate. And we'll be covering it. I love you guys.
Okay. Yeah, I'm not gonna sit here and I'm not gonna lie to you. All right. You're gonna probably stand there for a day.
That's my name.
All
Don't
right.
wear it up.
Possibly. It's all up to the judge. All right. This the thing is that the reason why they do that, man, is because it's domestically related. All right. Y'all agree. This is still big violence.
Yeah. That's when you do
Okay?
it.
They gotta make sure they keep y'all separated long enough to where nobody can come home and kill each other. You know, I know that might not be your intention. That's the majority of the domestic violence and dating violence, battery calls that we deal with. That never happens, but there's always that one out of many that will do. That's why you'll probably sit in jail for maybe a day or two. Okay.
Okay. So I wanted to show that last one so you could see who her boyfriend was when he was among the living. That was during one of their arrests where he was arrested and Sarah was arrested. So they've had this domestic violence thing going on for years. Sarah Boone committed this crime all the way back on February 24th, 2020. And she's been sitting in the Orlando jail ever since. And I think she's afraid. She's afraid to go to prison. So I'm no lawyer, but I think she thinks that, you know, the longer she rides it out in the jail, because you usually get time served, that she thinks that she's not going to be shipped off to prison. How many of you think that she's going to go to prison, even with spending 4 years in the Orlando jail, zipping up your boyfriend and passing out? Do you think it constitutes more than 4 years incarcerated? How many years do you think such a thing should be allowed to go on? I think she should go to prison for at least 10 years, at least. Not for the rest of her life. I don't think she deserves to go there for the rest of her life, but she deserves to go. I believe with all of my heart that girl deserves to go. She needs to go. Let me do a quick poll. I always feel like Ryan Anderson when I whip out my poll, but I want to do a poll and see how many of you think she should go to prison. I did a poll at the other live. I had problems with it, so I had to restart the live for StreamYard. But I had the poll ready. But you know, the best laid plans. Okay, so here we go. Should Sarah Boone go to prison? The big house, baby. Yes, no, and I'm going to add an option where you can just say, I don't know. I don't know. Okay, there we go. So let's back it up. Sarah Boone has been, she had 8 lawyers, and finally the judge, 8 lawyers and 2 judges, and finally this judge, Judge Kranick, has said to her, you know what? We have tried to give you lawyer after lawyer after lawyer after lawyer. Now you're your own lawyer. People predicted this. Even lawyers predicted this. And here we are. And of course, she's not happy about it because she knows she's screwed. Sarah is the original Karen. She's an original Karen. She's an OG Karen. She just is. She is where the word Karen came from. She is a white entitled woman who is entitled. And it's a horrible combination, in my opinion. Coming from, like, I probably came from the same background as Sarah. It's very easy to fall into that. Like, yeah. And it's so unappealing. It's so unattractive. Sam R says, I recently watched a video focusing on George. He was a victim of DV, in my humble opinion, 15 to 20 years feeling that. Oh, where did you see this, Sam? I would be very interested in playing some stuff on George. Yes, all opinions are welcome here as long as it's given with love. I think she's comfortable in the jail. I think she is too. Very comfy. And you know what? She's queen bee now, probably in that jail. Ship her off to prison, and it's going to be a different story for Blaine Boone. All right, so let's get into it. Let me share my screen. Be sure to, I'm not already sharing. Be sure to give this live a thumbs up. Helps us go out into the algorithm. Party out there. Bring more people back to the party. It's just a free way to help me out, and it's really, really appreciated. Be sure to check to see if you're subscribed as well. We've gotten over 600 subscribers in the last 28 days. So welcome to everybody. Welcome, welcome, welcome. Welcome to all the new dragonflies. That's our membership program over on YouTube. We're coming to you on YouTube, Facebook, and Twitch. Hi, everyone. Okay, so Vinnie Politan investigates, did a Sarah Boone represents herself in court. I always like what he has to say. So we're going to start out watching him. Everything is for fair play use. I will start and stop things. I will talk over it. I will put everything that we view during this live down in the comments. And if you want to go watch it or read it on your own, I totally understand. And you will have the links to be able to do that. And everything is my own research, my own opinion, and it's for educational and entertainment purposes only. Okay, let me make sure you can see what I'm showing you. Sam says, okay, let me look. I'll try to find who it was. I watched too much stuff. Well, even if you send it to me, I can do it on another time. Another day, we can do a whole live dedicated to Jorge, because I think that's important. Criminal intent and Katrina Marie video uploaded 6 days ago on YouTube, because I know a lot of people are YouTube, TikTok, back and forth. I'm not, so I don't love TikTok as much as I love YouTube. So I would call myself a YouTuber over a TikToker. I only do a little here and there on TikTok, but I don't know, maybe if I did more over there, I'd like it. But I have a plan of attack. I'm tackling YouTube first, and then my eyes are going to be set on Facebook, and then we're going to move over to Instagram, and then TikTok is like down the line. So yes, YouTube. Okay. All right. So this is Vinnie Politan. We'll watch a bit of this, and then we'll skip over to the motion hearing. We've got some of her letters to look at. We also are going to look over on the court page of all the filings and motions that's going on, and it has the final date of when the hearing is supposed to start. So we're going to go over all of that today.
Dismembered. This case is different. In this case, Sarah Boone is accused of using a suitcase as the murder weapon. Here's the story. On February 24th, 2020, Sarah Boone and her boyfriend George Torres were spending an evening together at Sarah's home. The two were drinking, and what happened that night is almost inexplicable. George got inside of a suitcase that was then zipped shut. At one point, he wanted to get out and pleaded with Sarah to open the suitcase, but she refused. Instead, she turned on the video camera on her phone and started to record as George begged for his life. George died inside that suitcase, and now Sarah has been charged with second-degree murder. 8 different attorneys have tried to represent her, and all 8 have dropped out of the case. And now Sarah Boone is representing herself. It's the trial that some think will never happen, but everyone is waiting for. Sarah Boone.
I think personally, she's also trying to get a plea deal. I think she's really wanting that as well.
Boone and the suitcase murder. There's a piece of video I'm going to show you right now. This video is the most important piece of evidence in the case. It's also difficult to watch because we know what is happening. It's a video of George Torres locked inside of a suitcase, begging for help, begging for life. Let's take a look.
It's a really hard one to watch because can you just think about your own self being in there and knowing that it's a hit or miss that this woman's going to let you out, and then to suffocate that way. To me, that's got to be one of the worst ways to go.
Sarah.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Sarah. I can't breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
That's on you.
Sarah.
She's so disgusting.
Real or ransom. Might want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you drink on me.
Sarah.
You.
Breathe, Sarah.
Yeah.
I feel like when you cheat on me,
You should probably shut the up.
Sarah.
It's hard to believe that someone would do that. And it continued. Not everything is recorded on video, but he's in that suitcase all night.
I think that might be what it is. It's hard to believe that somebody would do something like that, but she's got supporters. So she's not the only one in the world that I think would do something like that. And so that's why it's important for us that would never do something like that to kind of, huddle and band together so that why do you watch true crime? I watch true crime so I'm aware of what's going on out there. I think I watch it because it makes me feel safer, as weird as that sounds. I feel safer because I feel more aware. Like I have an idea what I would do in situations. I mean, we all, act weird in certain situations, but if I were attacked, I have ideas opposed to where if I thought like, oh no, that'll never happen to me. So why are you interested in true crime? I'm really curious. Put in the comments, why are you interested in true crime?
Long. So to understand the story and understand what was happening that night with George Torres and Sarah Boone, I think we've got to answer this first question. Let's take a look. And that question is, how did George get in the suitcase? When I say that, I mean, like, what are the circumstances surrounding what's happening that night? What's happening in this relationship? What are they doing? Why is a grown man zipped inside of a suitcase to begin with? Let me bring in my experts to help us through all this. Relationship trauma expert, psychotherapist, and CEO of Life Counseling Solutions, Dr. Jenny Lacey is with me. Also joining me, private investigator with over 20 years of experience, criminologist and profiler, Jason Jensen. Great to see you both. Dr. Jenny, I want to begin with you because I think part of it is the relationship here, because he's calling her babe. So they're obviously an item, they're dating, they're in each other's lives, but she's being very, very cruel at that moment. So what do you think is going on in the relationship or going on in their lives that would result with him inside of a suitcase, locked?
Well, we can assume they had a very toxic relationship, Vinny. And when we look at relationships that we would call toxic, we would look at something that we call a trauma bond. A trauma bond is where the person who hurt you is also the same person you're trying to get to love you in its most basic form. So when we look at some of the things that she's saying in this video, this is how I felt when you're cheating on me, we can make some assumptions that she's holding a lot of resentment and a lot of hurt, and they've gone through a lot of difficulties in their relationship.
We
And
know that they have because there are police reports and their past things. So yeah, I would agree with the trauma bond analysis here, for sure. And I believe there was domestic violence on both sides, which happens a lot in DV. But usually there's yeah, I don't know. Sam, one of our listeners in chat has said that he has seen a few videos covering Jorge or George. A lot of people call them George. We kind of go back and forth and call him both. But I want to definitely cover him because he is the victim in all of this. And I always like to talk about the victim. And I haven't really talked about him too much. And so be looking for that as our next Sarah Boone video. But yeah, the trauma bond sounds right here.
He's calling her babe. There's a term of endearment there and trying to appeal to her loving side to get her to open that suitcase because he couldn't breathe. So this relationship, when we're probably going to dissect it through this case, can probably reveal a lot of what was in her mindset, whether she was under the influence of alcohol or not. That when someone is hurt and someone betrays their trust, and there's a lot of toxic dynamics in the relationship, it can be hot, cold, come here, go away, I love you, I hate you. A lot of those dynamics, like a roller coaster, can exist in that dynamic, Vinny.
So, Jason, in investigating this and trying to figure it out, right? We've got some statements from her. We're going to play one of them in a second.
Yeah, YouTube and other social media, Sam, certainly have opened my eyes on the way people behave. Like sometimes when another creator is behaving poorly, I hear other people say like, why, how do they have supporters? And I say to the people, they're not the only bad person in the world. It's just like, I've learned this. And you know, it is what it is. And I just try to attract those that are on the same vibration as us, which is here all opinions are welcome as long as you state them respectfully. I'm not going to scream at you for disagreeing with me. You're not going to get that here. I might state my opinion very firmly, but other opinions are welcome here. And there's just a lot out there, but there's a lot of good out there too. We've got to remember that if we're going to focus on these dark subjects, we also have to focus on the light, and there's light among us, and we bring the light. And that's just really important to me.
Second, but in terms of the evidence, is there a way to examine whether it's the suitcase, the scene, or anything else to try to figure out how George Torres got inside of that suitcase and zipped shut?
So obviously, the first thing we would look for is some kind of signs of trauma on Mr. Torres's body to see if he was placed in there like while he was unconscious or after some kind of altercation, if he was beaten and forced in there, or if there is no sign of injury, then you would probably assume it was voluntarily, like she claimed.
Well, she tricked them to get in. There's another, I don't know if it's a video or a photo of Sarah Boone and her ex-husband zipping her son into a suitcase. Like, I think it was like a game, and Sarah thought about it and it was like, I'm going to play this game with him, but he doesn't know that once you get in, you can't get out. She probably was like, yeah, you can unzip it from the inside. I don't know. They were drunk. I'm sure that's like how it kind of it went down, in my opinion. Let's skip forward a little bit and look at the actual day of the crime.
How am I going to explain this? And she really exhibits no emotion for a long, 3.5 years of a relationship.
All right, my guests, Jason Jensen, Dr. Jenny Lacey, staying with us. When we come back, our next question. It was a crazy night, but did she even remember it?
Her trial is starting in October. I have the dates. We're gonna look at the My Clerk and go over all the dates of like when they're going to be doing the jury and all that good stuff and what's been going on. Because I mean, there's a lot. It's been fast and furious. There's been a lot of stuff happening on her case, and I didn't even know it. So I didn't even know it. Well, I knew it kind of vaguely, but I've been really engrossed in the Gypsy Rose case lately and the Chris Watts case. So yeah.
So I came downstairs and I was like, oh, he's in the suitcase still. That's when I found him. I took him out. I tried to do a cigar and then I called him and then I called you guys.
Was a reporter brutally murdered for digging too deep?
His death was absolutely devastating.
Sorry, these are...
You're joking, Mara. You put him in there jokingly. Would you leave Lucas jokingly in there? And you love Lucas, right? And you I wouldn't do that to him either. I wouldn't do that to him. So I just
well, so
like, again, I don't think you all understand. Like it's I mean, it's not that was not my intention.
Well,
y'all don't have any idea what I did for him.
But by your action, that's exactly right. You get to the point where you've done so much for somebody and they don't show you any appreciation.
He did.
Not by your words in the video. I don't get that.
We have lots of instances of Sarah Boone speaking on video. We have her while she's recording George inside the suitcase. You've got her there in the interrogation. She also spoke to the responding officer and the 911 call as well. So we've got lots of places where she's telling the story. I want you to listen to what she tells the responding officer about what happened.
We have a puzzle that we started in there. Okay. We've been doing art, trying to take stuff off the wall to make new art kind of there, like having a good time with one another. But we're drinking. We had a bottle of wine last night. Okay. So then it's like, we decided to play hide and seek, right? Okay. So he gets in the suitcase. Okay. Who is this guy? That's my ex-husband, my former husband. How did he live here with you guys? No. I called him over here. Okay. Okay. I didn't know what to do. Okay. I didn't know what to do. Okay. So then he came over here. Here, let's talk in private. Okay. I called you guys. And tried giving you brother. I think the problem is I fell asleep. I fell asleep. When did you do CPR? This morning. When I found it. Before you called? Yes. 1 o'clock right now. I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs and I was like, oh, he's in the suitcase still. That's when I found him. I took him out. I tried doing CPR and then I called him and then I called you guys.
Did he get here before the fire department got here?
Who?
Your husband? Or your ex-husband?
Yes.
Okay. Where did you live at?
Right down the street.
Okay. So you were playing and you did some up there?
I did, but then I fell asleep.
Okay, okay. You're okay. I wasn't here. I'm just trying to figure out what happened.
I fell asleep. I don't know if he suffocated or like had an aneurysm or a heart attack or what.
What kind of medical conditions did he have?
None that I know of.
Nothing that you know of.
None
Did
that
you
I
take
know
any
of.
medicine?
No. All we had was a bottle of wine. Literally, just a bottle of wine.
A bottle.
Artwork. Then we decided to play hide and seek. That's all that happened.
Okay. The story changes a little bit. There's some pieces that are left out, but there are points where she looks like she's shocked by what has happened here, which brings me to my next question. After this unusual night, did she remember it? Like, did she even remember what had happened here?
I always wonder that too. When she's sitting in the police station before they and they sprung it very poorly. I mean, the battery died. Before they sprung it on her that there was that video, she was like acting like the video never existed. So like, did she think that because did she know about the video and deleted it? And did she think because I deleted the video, they'll never know about it? Or was that truly like an, oh my God moment? And, or the number 3 could be, was it truly an, oh my God, then she remembered it moment? Like she didn't know anything about it. And then she remembered it because she didn't want to look at that video. Remember, she said, do I have to look at it? And they're like, well, you can do whatever you want, but this is your case. Shouldn't you look at it?
Let's bring back in our guests, Dr. Jenny Lacey and Jason Jensen. Jason, what does your gut tell you as she's telling this story to the first responding officer and is like, you know, I woke up and then, and it's like, does she even remember what had happened that night?
you have to ask yourself if she's even recounting the events as they take place, because for starters, they don't really match up with the video that she took on her own phone. So why is that? Is it a deliberate error, or is it intentional? Like she is hoping no one will find that video and she's making this up because she's acting like she's surprised. She's acting like she's shocked. But is it really an act, or is it because she doesn't know? She doesn't remember because there was drinking involved. So if she's so inebriated that she doesn't remember, then how well was she operating, conducting herself the night before when this all happened? That's really what you're going to want to try and figure out, is if she's so inebriated, she can't even walk or talk or conduct herself. So, that's what the evidence shows.
Dr. Janie Lacey, what I want to do, because I think Jason brings up a great point here about the drinking. I want to play another piece of the interrogation where they talk about the drinking. And we've heard her say, we just had a bottle of wine. Let's watch.
You told me but you told me on recording, like, that you were not drunk, he was not drunk, you guys were having a good time.
I can't get drunk. Number one, I do not want to get drunk.
Towards the end of the interrogation, though, it was like, we were drunk. Here she's like, I never get drunk. I'm not a drunk. I don't drink. I'm an A student. A students become drunks too, Sarah Boone. But anyway, she goes full circle and unintentionally. She says unintentionally. Like, if I were a college student and I was into true crime, this would have been one of the ones that every time she said unintentionally, we would have drank. Because we would have been drunk as Bling Boone.
Like being non-compos mentis, having my wits about myself. I don't like feeling out of control. Mm-hmm. So
I'm just saying, you're making it sound.
And you guys, I do like to joke around. I'm a Gen Xer. It's the way I deflect uncomfortable situations. So sometimes people get upset that I make jokes, but it's just who I am. I'm not trying to offend anyone. A lot of Gen Xers do this, and I know how serious and horrible it is, but I can't stop making fun of Blaine Boone. I just can't.
Like he's a raging alcoholic today, and yesterday I was kind of asking you those questions, and you're like a little defensive, like, no, we're not alcoholics. We are not, but you guys were both sober on Sunday, to your knowledge, because when I said you went and passed out, you were like, no, I didn't pass out. I just fell asleep. So now it's kind of like, what is it? Were you guys drinking and it got out of hand and it got physical?
No.
Or is it?
Sunday was one of the better days that we have had in quite some time.
So where were you guys at on drunkenness, not drunkenness on Sunday? You told us you weren't drunk.
No, I was not drunk. Right. I was not drunk.
Okay, Dr. Janie Lacey. I'm not an expert, so I'm not going to give my opinion here, but I have one about whether or not she was drunk based just on the sound of her voice in that video. But what are your thoughts? Do you think it's possible that she blacked out here and didn't realize all the things that she was doing? Didn't realize that she was taunting him? Didn't realize that he was begging for his...
I think it was part 3. C, A, B, or C, when I gave them off. First was that she didn't remember. She remembered, but she was just pretending. 2 was that she didn't remember at all. And C, I'm sorry, I'm going back and forth between 1, B, and C. A, B, and C. A remembered, B didn't remember at all, or C didn't remember at all until she saw the video. And then it was like, the memories came flooding back. So A, B, or C. I think it was C.
His life?
Well, there was a lot of contradictions as we were hearing from her own words. But when we know that people have blackouts and they don't remember, her reaction afterwards would be what is contradicting to people who do black out when they've drunken too much, because her reaction would show that she's very distraught. She's shocked. She couldn't believe these things have happened. It's someone that she loved her. So her reaction and the shock of her boyfriend being found dead would appear, in my opinion, to be very different if she did not remember exactly what happened. So, the only other bucket that we can probably consider is that, yes, she was under the influence, but did she maybe not intend to deliberately hurt him, but wanted to punish him because of the taunting and all these types of things? That would leave me in a little
for sure. I don't think she sat there and was like, I'm gonna unalive George tonight. I don't think she thought that at all. Hey, Tony, how are you, honey?
Bit down that type of path, and then obviously we now see her trying to make up the story or to try to piece what happened to make sense to the investigators, because you could see the defensiveness when certain levels of questioning is asking to her. So her reaction is very out of proportion to someone that would have a blacking out and then they wake up and realize what exactly has happened. It just doesn't add up to what we would normally see.
Jason, as we've seen these different statements, right, beginning with the video itself, we know what's going on there, the 911 call, the responding officer body cam video, and then the interrogation. There are some consistencies there, but what are you hearing and noticing from her telling the story or speaking in 4 different times in 4 different places?
I think what I see that stands out to me the most is her voice, what she's saying during the recording of Mr. Torres in the suitcase, because you do occasionally hear some slurring, you hear some vindictiveness, some resentment. So one of the things I understand from my education and experience concerning alcohol use is that that's an inhibitor reducer. So a good illustration is if you're a happy drunk, a happy person, happiness comes out. If you're an angry person, an angry drunk comes out. So this, while she's drinking, she even admits it during the interrogation that she doesn't like.
So when I would drink, I would go through a cycle. At first, I would be very happy, and then I would get very loving, and then I'd get tired and I get kind of nasty. So I would go through a whole cycle of what was going on. And yeah, I get migraines now when I drink. So I don't even really have the desire to drink because I can think about alcohol and carry it through and think about what the migraine will, because my migraines affect everything in my life. Like I get sick to my stomach. I get it in the smells. I get it in the sights. I get it in the sound. Everything's got to be quiet. I get it in the light. Everything's got to be dark. So, and it goes down into my arm and up my neck. And I tell you, once you've had that for like, it used to happen. I was so stressed out when I was a social worker that towards the end of my social work career, I had migraines so often. I was trying different medications and they were all doing weird things to me. So if you know, you know. But I would, when you guys drink, if you ever have been drunk in your life, what kind of drunk are you? Are you like a happy drunk, a mean drunk, a standoffish drunk? What kind of, and not even like a drunk, like when you drink, do you get giggly? What do you do?
To lose control of herself. So she knows that this mean person comes out when she's drinking. Now she's trying to walk it back.
We have about 30 seconds here, Dr. Janie Lacey. You find any significance that the first call she makes in the morning is not 911, but is her ex-husband?
There's a lot of significance in that, because if you're waking up and you find out your love of your life at this moment is not alive anymore, your reaction would be to get him help, to call 911. But to call your ex-husband and then having that delay is very, very strange and out of the norm of someone would normally do.
Very weird that she calls her ex-husband and not the police, and he tells her to call the police. Like, Sarah, what are you gonna do? Your ex-husband, what do you think he's gonna dig you out of something? I don't think that's gonna happen. Let's move on and go into talking about her latest trial update, and it was a big win in court for Suitcase Sarah. Sarah Boone, the Florida woman accused of unaliving her boyfriend by trapping him in the suitcase, was handed a major legal win on Friday as she prepares to represent herself in her upcoming trial. Boone is now free to appear in court without handcuffs, and her leg shackles will also be removed once her trial begins on October 7th after Orange County Circuit Judge Michael S. Kranick approved her handwritten motion. I mean, how could he not? Like, most people get their shackles taken off, don't they? Like once they go into trial and stuff. I don't know. Yeah, I think they do, because they want you to dress in street clothes because they don't want you to appear like you've been sitting in jail. They want you to have a different appearance to the jury, which, I mean, even though they know she's been sitting in jail, it will make you think differently the way someone's dressed. It just does. Than not seeing her shackled. The 46-year-old Florida woman was charged with second-degree murder related to the 2020 death of her boyfriend, Jorge. Boone lost her right to legal counsel in June after she went through 8 lawyers, with multiple resigning due to irreconcilable differences. In her motion, Boone requested to be unshackled and unhandcuffed in the courtroom so she could turn pages, pick up objects, open documents, pass information, utilize a laptop, and freely perform other normal movements. We'll be looking at the letters, so don't worry. Don't you worry. We'll be looking at the motion, and we also will be looking at her ad for a lawyer. I'm just asking to sit here unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable, Boone said at Friday hearing. Orange County Sheriff's Deputy Gavin Lotan voiced his disapproval of the motion during his testimony at the hearing based on the charges she's currently facing and previous domestic violence arrests. He also alleged she has refused to come to court in hearings on 3 separate occasions, which she has. But I mean, I'm surprised like they're fighting it, but not surprised at the same time, because I'm sure Sarah Boone has made a lot of people uncomfortable and a lot of people unhappy with her constant. Sarah Boone is one of those people. She's like a Daryl Brooks, where she'll ask for something and you'll say no. And then she'll ask for it again and you'll say no. And then she'll ask for it in a different way and you'll say no. And then she'll ask for it in another way and you'll say no. And then she'll ask for it in the old way and you're starting to get wore down and you're like, holy balls, just stop. But she will wear a person down. She will turn them around until finally they're just like, effing take it. Do it. I don't care. That's Sarah Boone. When you combine all that, it shows a propensity for violence and not wanting to follow lawful commands and orders from law enforcement personnel, Lotan said. Boone challenged Lotan's claim. I've never missed a court date. In the almost 5 years that I've been here, I've never argued. I've never hesitated, Boone said. I don't think she missed a court date. I think she refused. She walked away from her lawyers during when they visited. I think that's what she did, now that I'm thinking about it. Because she wanted to be at everything. If, you know, it was just a hearing to hear the judge pass gas, Sarah wanted to be there. That never happens. That was just a poor example. But I couldn't think of anything. But Sarah wanted to be at everything. Court records from a hearing on January 28th. This is probably going to make me a liar. 28-21 state Boone will not be present because she refused. Right there. Kranick ruled in Boone's favor during the trial. She will wear a stun cuff. Oh, interesting. Courthouse, we got to get our people that have been in prison and our deputy sheriff, prison deputy sheriff on here so that we can talk about this, because I have never heard of a stun cuff. Courthouse deputy Chad Barnett explained during his testimony that the wireless cuff is secured to the leg and can discharge 50,000 volts, which could cause the person wearing it to fall. One deputy will be in charge of monitoring Boone and controlling the cuff during the trial. Boone will appear in court on Wednesday to discuss how she can view the evidence in her case. Is this new, this cuff thing? And I thought I saw other people without their shackles on, but maybe they always have the shackles on. I know like some of them don't have handcuffs on, right? Or do they all have? Now I've got to look because I thought some of them didn't have handcuffs on. I don't know. You haven't heard of a stun cuff either? Oh, Tony, you would get giggly and fun. I think as we all get older, it's just like, I don't know, it's just not a thing. It's just not a thing anymore. And you're dealing with like body things that you've never imagined dealing with. Like, I would go back to be 30 again just to not have all the aches and pains. You don't even have to do anything and wake up in pain. It's just the way it is. Okay, so let's keep going. And let's look at which one do you want to look at next? Do you want to look at the motion hearing, or do you want to pop over to the court site, the record, look, the my clerk, and look at all the stuff that's going down? Well, let's do the motion first, and then we'll wrap it up with the court. I also, at the very end, I am doing a Baby Banny update. Baby Banny is the Indian elephant that was hit by a train along with her mother. There's laws to prevent this, but the train companies are not following the laws. Banny's mother didn't survive, and she couldn't walk or stand. And a year later, they have her back on her feet. It's incredible. And we have been buying her bottles, milk bottles. And yeah, I wanted to do a quick update. So let's look at the hearing first. But I have to decide. Hold on. Okay, here we go. And it's an hour and 47 minutes, so I'm going to be skipping around on this, but you know, the link's down in the description if you want to watch it all. I am always, Sarah strikes me as the type of person that will stare a camera down. I wonder if she's going to do it. Do you think she's going to stare us? She going to look at us? Come on, Sarah, look over here. There it is. There it is. Hi, Bling Boone. I actually prefer Suitcase Sarah. Oh, Daryl complained that he was being shocked with. He had one on. I don't remember him saying all that. I do remember like them moving him to different courtrooms because he undressed. And I mean, I don't anticipate Sarah doing any of those antics, but I think we're going to get some antics, and it will be interesting to see what we get. Like, she thought she was going to get co-counsel. Co-counsel only happens when you deny counsel. Sarah is the one being denied counsel. They tried to give her 8 counselors, although some had to excuse themselves because it was a conflict of interest. Like, probably had something to do with the past domestics or whatever. But she wrote these horrible letters about her counsel, the last one being very long, 58 pages long. And the judge was like, okay, you're done. Let's move it up. Let me see how fast I am.
Case number 2020 CF 2603, the state of Florida versus Sarah Boone, state.
State Cashapp, out of state. Will you make the state?
Ms. Boone, raise your right hand to be sworn, please. Please swear to affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 1077.
I do see that we have a representative from JACS that's appearing virtually. So can I get you a
putting on a little bit of weight. I think it would be impossible to remain thin in prison or jail, only for the mere fact that I would have to eat through commissary. I don't think I mean, I guess after a while you'd get used to it, but I don't know. I would be dipping into commissary a lot. And then what else is there to do, you know?
For the record as well.
With prison reform, I think there should be more to do, but I don't anticipate she's doing a lot.
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 2024, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024, and received July 29, 2024. I have reviewed all of those motions. All 3 motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Whoops, sorry, I had me muted. Junie's back in the party. So that is where that's where Daryl got the electrocution from. I didn't quite understand where or how he thought he was being electrocuted. I thought it was just him making it up in his mind. Thank you guys. Thank you. It's another reason I don't like to bring Junie here. I forget when I mute myself and then I start talking and I'm muted. But Okay, got it. I'm interested in the Daryl Brooks case. I've wanted to go back and rewatch his trial, and I probably will do it this winter, or maybe even when we do our friend. Can we zip it? You know how a lot of creators do Vlogmas? Well, I do Livemas over here where we do a live a day. So we'll probably maybe dip into some cases to look at, because we're going to have a live a day for 25 days in December. And I'm also doing something for the 13 days of Halloween, planning that. I'm actually wanting to plan that with other creators. So if you're a creator that would be interested in collaborating in October, email me, parawomenradio@gmail.com. And the women is plural, not singular, plural. So WOMEN, PARAWOMENRADIO@gmail.com. Okay, let me get back into this.
Not really, Your Honor. The only thing is, if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions, we would be happy to send her a copy, or send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was as to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you're seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline, or at least meet it. So I don't know what I'm supposed to ask for, or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to, With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate. Okay.
Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decide at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to stand by counsel as decided by Paul versus State 152, 7th, 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449, 7th, 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State 45, 7th, 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State 17, 7th, 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I do not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy to even understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is regards to competency as opposed to having understanding before you take someone's right away.
Ferretta pertains to a criminal defendant's seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I didn't know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand for attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay, I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You wouldn't, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Oh, Sarah's been making everybody aware of that. Over and out. We got you, Sarah.
All right.
Is that funny?
My
Jim?
judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of these state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with the laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense, yeah. And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone.
That's an interesting coat he has on.
From attempting to move that.
This is in Florida. Okay, you guys. So what is this? This is interesting. I've never seen this before. I would think it was an outer coat for like outside, not a suit coat, but are they making suit coats like this now?
Piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
go ahead, sir.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list and the USB.
Yeah, we're going to make this work for an October 7th trial date, Rich. I think September 1st is probably about the right time frame.
They're doing the 7th, October 7th.
Lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it?
It's like a winter outside.
Or are we talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence.
For them having Sarah represent her, like what a pain.
It's viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality. It is all done in the courtroom with everyone?
It would be in the courtroom, correct.
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that have met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know.
This is why I heard about this little piece of, in this hearing. And this is why I think she wants to cut a deal.
Bring physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions. And then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cashapp would be out there, and our investigator would be out there, and we would record it. The conversations that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present. And then that way the digital evidence is now open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has with my investigator and then be able to come with the objections and everything.
That is correct.
I'm clear on.
Who is the guy up on the screen, you guys? Who is this guy up here? Does anyone know who he is?
Field bags and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time, though, it is my understanding that I should have some right to privacy in reviewing my the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it. But it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transferred anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in the court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing.
She's not allowed to stand by counsel. Like, there's going to be nobody standing by with her because it's different. She didn't refuse counsel. She's being refused to counsel because of her behaviors. She didn't pull a Daryl Brooks and was like, I want to be my own lawyer. And then the judge will always be like, do this whole thing. Are you sure? Like, this isn't a good idea. And then they'll appoint standby counsel. And so she thinks she deserves that. But this is different. She had 8 lawyers. 8.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So if you could please look into that, because I disagree with the media being involved in that.
I understand your position.
Because Sarah is very wise about these things, because Sarah is an A student and Sarah has fans and the whole world is her stage and you're watching her. It's her show, baby, not yours. Sorry.
Again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from the dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, the USB drive or the after our viewing here in court stays at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically.
We are happy to defer to the defendant's wishes on that.
She does get to have her own private investigator. So that could be like, I get what you're saying about like, that's really like her pretend. You've got to always got to spill your food, don't you, Junie? You can't leave it. It's always got to be spilled. I think the private investigator, they're kind of using as like what Heavenly said, like a behind the scenes, unofficial lawyer, or at least is helping her out. I don't know.
I want to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. it should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay, all right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
It matters.
So this meeting is separate. This is prior before everything else.
She's super
What I would
busy.
envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion to be had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing the list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you all supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself, bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring it with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has the type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You provided a copy of it?
This is where I'm talking about she went at it over and over with the laptop, and the judge was like, you got to follow protocol. And I believe in the end, the judge was like, fine, take it, have it, shove it up your ass. I don't care. Not really, but I think he did end up giving it in to her.
Through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with your harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and was provided by U.S. mail. It was sent out last week.
I didn't get to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you were speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by U.S. mail? Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with.
She's trying to change the subject to confuse the matter. People that try to get their way will often do this. They'll take you around the mountain to get, they'll be like, oh, and I have this other thing I want to talk about. She tried to do it. And he's like, no. Let's come back to the USB. We'll handle the other things later. But of course, then she had to talk about the mail. She couldn't stop herself.
With regard to USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you.
It's also hard for me to look at Sarah because I have issues with my mother, and my mother makes those same faces. Like, I don't think Sarah knows she's doing it. And if you do it, I mean, I'm just saying, it just triggers me and reminds me a bit of my mom.
From 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know if anything that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing.
Okay, Sarah, the court knows what to do.
So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order being, unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th, And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I will be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get fast.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could file that notice, just to identify when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to one of the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have a laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a rate restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptops in quotes closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by 3, and I have I have that to also be looked over.
Okay.
9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay.
Okay, it's just hard to believe that Sarah's looking at all this time and she did it to herself. She did it to herself. Let's move on. I will put the link to this down in the description if you want to watch it all. She won the battle of the not wearing any cuffs. They're going to do like a zapping one. But she did lose the battle. She did lose a battle. Hold on. I've got so many things open now. Yikes. And now my browser lost connection. Hold on. I got to stop sharing and reshare it. Sorry about that, you guys. StreamYard's been real glitchy, really glitchy the last, I would say, 2 weeks. I would just be terrified if I was Sarah Boone having to do this all myself. And you can tell she's like a little like, oh my God, what have I done to myself? Like she cut her own nose off to spite herself. And there she sits, noseless. Sarah Boone suffers another legal blow. You stop it, sir. In bizarre suitcase murder case. Let's skip over that. It's all Orange County Circuit Judge Michael S. Kranick, who is presiding over the case, ruled that Boone forfeited her right to legal counsel on June 28th after she went through 8 lawyers. Several cited irreconcilable differences as the reason for resigning. Boone appeared in court on Monday for a hearing on several handwritten motions she submitted from jail, including one for standby counsel. So in the end, she lost the standby counsel, but she did get the right to wear these zap cuffs. Zap cuffs, I guess. What are they called? What did they call them? I don't remember what they called it, but they're cuffs that they put around and they'll zap her. They'll give her a good zap. So the Kranick ruled in Boone's favor during the trial. She will wear a stun cuff, not a zap cuff, a stun cuff. Courthouse Chad Barnett explained during his testimony that the wireless cuff is secured to the leg and can discharge 50,000 volts, which would cause the person wearing it to fall. So Sarah would do a nosedive if she tried to leg it. Let's go on. I saw this that I thought was interesting. Hold on. Open letter to Sarah Boone regarding her most recent letter to the court. This is over on Reddit, and it goes on to say, let me make sure you're seeing what I'm saying. You are, okay. It goes on to say, I know you most likely can't read this yourself. That's fine. Somehow she's getting our information, so maybe she'll hear it if I read it. This is really just to vent something. Note, I'm not a lawyer, but I've heard enough and I've seen enough firsthand to be able to confidently post about this much at least. And I know everybody else is busy talking about the ad, which we're going to look at that in a minute, which nice formatting and use of different hand-drawn fonts. I actually wanted to talk about a different portion of your letter. One I doubt many others. Oh, Junie, stop. You stop. One I doubt many others will be interested in, because this part of your letter indicates to me that you may have fundamentally misunderstood this entire time. How these, okay. All right, you're going in the back. Go in. He's getting, the natives are getting restless. Because this part of your letter indicates to me that you may have fundamentally misunderstood this entire time how these letters became public in the first place. How about by the copy machine where your JAs should have made me the news crews, court TV, professional YouTubers, and photographers the world a copy of the notice of curing. We're all informed. This is from one of her letters. Improprieties occurred, and then some, including the drop off of my case materials, said order being ordered, and me being pulled by my uniform to exit your courtroom while still trying to speak and defend myself against all the mayhem and chaos, especially the surprise at even being there unprepared and without notice. Oh, wait, my posting everything supposedly is public record, and there's no notice at all. Another, it's your favorite moment. It's all group effort. Saboteurs. Ooh, she's getting bigger with her words. This isn't the first time you said things like this or accused the judges in your case of profiting off the media publicly of the case. Sarah, are you somehow under the impression that every time you send something to the judge, the assistants rush to the copy room and print out dozens of copies and send them to news crews? Because that's not what happens. What happens is actually much, much simpler than that. What happens is when you send a letter to the judge about your case, they are legally required in the state of Florida to make it available in a publicly searchable database. This database, and we're about to look at it, is on a website that anybody can access. You just have to know the name of the case number or the case you want to search. You just really need to know the name. This isn't just you. It's literally every criminal case and possibly civil cases as well. Though I haven't looked. I don't know that either. In the state of Florida, your correspondence isn't being copied and sent to news crews and other interested parties. The news crews and other interested parties are just periodically look up your case to see if anything new has been posted. To imagine that the court staff have nothing better to do than make and send copies of your correspondence to news crews. Do you have any idea how vain and or paranoid that makes you sound? I don't think she has any self-awareness. Any whatsoever. Somebody says this may be true, but it's up in the air. She often seems dead set on her view that the judge in her case are actively sending her correspondence to news crews and YouTubers. In general, she strikes me as somebody who latches onto an idea and then actively avoids looking into it for fear of being proven wrong. So if she latched onto this idea, then even if she A, has access to a computer, and B, knows to look for the Orange County Clerk's website and do a criminal case search, I don't know that she would. But yeah, in general, everything she's doing seems intent on proving to herself that she's the victim, which is not the right goal for her to have at this point. It's actually insane. It's insane. This person says literally anything that might help her in some way, shape, or form might qualify as the right goal, whether that be physically or spiritually, whether that means pleading guilty or pleading not guilty and focusing on putting together a coherent defense for the jury. I need to prove to myself and everybody else that life is so unfair to me. It's not a coherent defense for the jury. And then this person says she's not a person with a coherent mind, at least partly, if not wholly physically, due to long-term alcohol poisoning, which in no way has helped her personality disorders. That's good points. In some ways, she presents as someone with early onset dementia, which has progressed pretty clearly over the past 2 years. If she considers it evolution in both her writing and her court appearances. Oh, if one considers it's evolution. Interesting. What do you guys think about this? Even if she were capable of putting together a coherent legal defense, which I don't think she She's not a lawyer. Although, as much as she thought she was a lawyer, she's realizing she's not a lawyer, which I don't believe she even remotely is. She has neither the training nor experience to even introduce it successfully during the trial. If the prosecutor objects, I believe they might, to anything, stop it. She submits. She lacks the capacity to respond such that the judge would overrule the objection. Even if it were somehow a valid defense or legitimate evidence supporting it, or even the objection itself is trivial or frivolous, she will not even be able to prevent the introduction of evidence that even a second-year law student, I agree, would recognize and object to as prejudicial, and the judge will not protect her without a proper objection being raised. I know for a fact I would not be able to do so if my life depended on it. I couldn't either, although I would be studying a lot if that was what was coming up. Without having years of formal education in a legitimate school of law and the breadth of knowledge and the temperament necessary to pass a bar exam, none of which I have or she has. Frankly, her best course is probably to announce for the record in court before, I don't know what that is, voir dire, that she recognizes she lacks the training and experience to participate meaningfully in any stage of the trial, from jury selection to introducing evidence and calling the cross-examining witnesses to closing arguments, that she has no tools to design or present, this is a good idea, or present a defense, and will therefore stand mute until the trial's conclusion. Then she would probably have a better chance at getting a new trial, sounds like. I know that will disappoint those who would love nothing better than to watch a circus and a mockery of the justice system on YouTube, but they're not the ones to whom the court conducting a solemn and deadly serious criminal trial should be pandering. Yeah. Actually, that's really good advice. I'm not a lawyer, so I don't know if that's advice that they can give. So yeah. Okay, so let's go on and look at what she's doing over, what's happening over on the judge's, the myorangeClerk.com. So here we have the original offense was on 2/23, that's when she was charged. And so the hearing is on 10/7/24. They have it. And they have on 9/26/24 is the trial management conference. They had it scheduled for the 24th, and that's been canceled. There's been some things sent about the affidavit of cost. There's been some notice of filing, and then there's petition of motion for attorney fees, petition of motion. I wonder if she's trying to get the attorney fees for herself, or is another attorney trying to get it? I don't know. And then see, they put everything here. There's a certificate of service. There's more notice of filings. Notice from prison break investigations. What are they? What's the notice? Oops, it's not giving me anything for that. Here's the court minutes from, why isn't it taking me anywhere when I click on it? Weird. It's not taking me to anything when I click on it. Are they not for the public? No, that wouldn't be right. Let me look for her letters in here. Here's something the court put. The court granted the defendant's motion to lawfully receive, review, utilize the organized hard copy discovery. The state provided Billy Lane, represented from Prison Break, thumb drive with the digital evidence in open court. Billy Lane to go out to the Orange County Jail to meet with Major Mohammed and provide him the 2 boxes of discovery along with the thumb drive to be provided to the defendant to provide in writing any objection she has to the digital discovery by 8/23. So there's the court minutes to be placed under seal. Oh, they were placed under seal? Interesting. Let me see if this opens up. No, why is this none of this opening for me? Ugh. Well, we have this. Never fear. I do have this. I opened, it was working before I went live. And I did open this up. And this is the letter she wrote on July 8th, 2024 to the judge. And we've gone over a lot of it. But I just wanted to look at the handwritten thing that you would add, that you would tape to a grocery store board, help wanted or seeking board, whatever those boards are called. Inmate seeks attorney. Let me make sure you're seeing it. You are. Inmate seeks attorney, looking for a prosperous challenge, ready for your close-up or on national television. Are you zealous with a side of keen? She thinks she's really keen. She thinks she's clever. Show the world who you are with your original creativity, extraordinary expertise, confident I can't say that word. I can never say it. Ingenuity. I can't say it. Qualifications must include, I can say it in my mind, but I can't, it won't roll off my lips. Being trustworthy, honest, passion-driven, open-minded, exceptional, problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency, and listening, communication, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently, overcome all circumstances. Endure, Sarah Boone. Epic opportunity awaits. Sarah Boone, number 2000-5623, Orange County Corrections Department. Invest in the oppressed. Believe. So that was Sarah Boone's little thing she did for the court. Yet she's really mad that all her stuff is getting out there, but you can't tell me she didn't know. She didn't know exactly what she was doing and making the font bigger and more interesting in places. She's just insane. What do you guys think about Sarah Boone? I gotta go I gotta go actually, because the natives are definitely restless. I gotta feed them, water them. You know the drill. I think this is all I have. Let me make sure. I do have some extra stuff, but we'll put it on the next one that we do. We'll read the letters and we will do the George Torres tribute. Oh, I was going to do the baby Banny update. I'll do the baby Banny update on my next live. But there is an update, and there's good things happening with her. And it makes me feel really good that we are supporting her. It makes me feel really, really good. Okay, guys, I'm going to go. Good morning, my queens. Blame Boone. I can't wait. I can't wait too. Hi, Cindy. Okay, let's get going. Hey guys, you certainly have made a huge, huge difference in my life. And if nobody's told you this today, and even if they have, I'm going to tell you this again. I love you guys so, so much, and I'll see you next time. Bye, guys. Hi, guys. Welcome to Parawomenradio. I'm Amy.
Carefully strumming this old guitar, words rolling out into the fire. Never ask why my heart burned blue. Here in the haze where you inspire me. Here in the darkness I hear my cue. Time to find some solitude. Here where my soul bleeds openly, deep in the heart